Hello class. Today we discuss alternative dispute resolution. Despite best-selling law movies and books based on their plots of highly tense and dramatic court cases, about 90 to 95% of real cases end in some form of a pretrial settlement in both criminal and civil court. Litigation is attractive, but it's not popular. Arbitration, mediation, and settlement are the alternative forms a vast majority of parties ultimately choose. When litigation through the courts is a method of resolving a dispute, the process will usually be time-consuming and expensive. However, there are a number of different options which fall under the general category of alternative dispute resolution, or ADR, to prevent or at least minimize the burden of full litigation. Arbitration, mediation, and settlement are usually chosen after both sides to a case have spent considerable time, effort, and money in preparing for litigation. The alternative form to litigation is typically chosen because one party gets cold feet on the eve of trial or exceptionally close to trial. Arbitration offers substantially the same benefits and experiences of traditional litigation, evidence, witnesses, arguments, and so forth. However, the atmosphere is less formal than the traditional litigation, and arbitration does not need to occur inside a courtroom since a conference room usually suffices. There are many pros and cons to arbitration, but the gist is that arbitration is the reasonably priced alternative to full-blown litigation. Perhaps what is most attractive after its cost, arbitration is just as binding as a final court order. Mediation generally means relatively friendly meetings between both sides with an experienced mediator. The goal of the mediator is to help the parties talk through their differences, find common ground, and reach a mutually agreed settlement. By definition, a mediator has no power to make a binding decision on the parties, although he or she may give an opinion on the case. Mediation is done with or without attorneys. A typical example would be the use of a mediator to resolve a labor dispute between union workers and management, resulting in a new union contract. Mediation is also successful in many divorce cases. Arbitration is generally recognized as a more formal process than mediation, where an arbitrator is jointly selected by the parties to actually make a ruling in the case. Each side is allowed to present their case. Arbitrators even have subpoena power in most situations. Many arbitrations are governed by the guidelines from the American Arbitration Association, which has a pre-designated set of rules for arbitration, plus a set of rules for selecting an arbitrator. A typical example would be salary arbitration in baseball, where the arbitrator's decision is binding. Arbitration is also a frequent clause in real estate purchase contracts. Another way to partially resolve issues and minimize the cost of litigation is to reach a partial settlement with the other side in a dispute. In many cases, the lawyers and litigants become so upset at the other side they are reluctant to reach any agreement, even on common sense matters. If the attorneys or other representatives can cut through the emotions, sometimes the two sides can literally establish a lengthy list of factual agreements, especially with regard to undisputed events or dates, and for admission of certain documents which can later be presented to a judge. This way, the attorneys can focus more clearly on the disputed issues.